I'm Spencer Mazyck, and joining me now is Jesse Witten. He's a partner at Drinker Biddle who represents a group of Native Americans in a federal action requesting that the National Football League's Washington, D.C. team loses trademark protection for the term Redskins. Welcome, Jesse. Thank you for joining us today.
Thank you, Spencer.
So, Jesse, in 1933, the Boston Braves became known as the Redskins before moving to Washington, and now your clients are demanding that the team stop using the term, the trademark, and mascot. Why?
We have petitioned the Trademark Trial and Appeal Board, which is a component of the U.S. Patent and Trademark Office, to cancel the registrations of the trademarks of the team. If we were to win, they could still use the team name, but the trademarks would no longer be registered trademarks. They'd be unregistered trademarks. The statute, the trademark law, the United States trademark law, which is called the Lanham Act, says that trademarks which contain matter that may disparage persons are not subject to registration. And if anyone is aggrieved by a registration, they can petition this Trademark Trial and Appeal Board to cancel a registration. So our clients have essentially gone to the Trademark Office and pointed out that the agency made a mistake back in the 70s and early 90s when it registered the certain trademarks of the Washington NFL team.
And so it's because they find that the term itself is offensive or they think it's disparaging, is that right?
The legal test is whether it may disparage persons, and yes, the term Redskin is an ethnic slur.
Many of the fans and the team's owner, Dan Snyder, argue that there's so much tradition in the name that has been used for more than 80 years. So are you saying that the tradition here doesn't matter, that it shouldn't matter?
The team name has been in use for about 80 years, but I don't think that if that makes it a tradition, that doesn't mean it should remain. Not all traditions are good traditions. We've had traditions in this country of racial discrimination and segregation, and fortunately we've gotten beyond those. I think it's also important to understand very clearly where this so-called tradition came from. The team was originally the Boston Braves, and a year later its owner, George Preston Marshall, changed the name to Boston Redskins, and then a year after that moved the team to Washington, D.C., where it has been the Washington Redskins. George Preston Marshall is one of Washington, D.C.'s most notorious racists. The team was the very last team to allow African Americans to play on the team. He opposed it, he fought it, he vigorously opposed having the team be anything other than pure white. It was only because in 1963 that the Department of Interior said to the team that if they wished to continue playing on federal land, which was then DC Stadium, now RFK Stadium, if they wanted to continue their lease at that stadium, they needed to integrate the team. It was very much over George Preston Marshall's ardent objections that African Americans were included on the team. When Marshall died in the late 1960s, he left a lot of money to charity to be used for underprivileged children who were white and only white. So this tradition comes to us from one of the most notorious racists that this city has ever seen. I don't consider that source of tradition to be anything that we should be honoring, respecting, or paying the slightest bit of attention to today.
And so, Jesse, according to a recent ESPN poll, though, most Americans actually don't find the term offensive. Do you think that's because they don't actually understand what it means? What does the term Redskins actually mean?
Well, the term Redskin is an ethnic slur used to refer to Native Americans. It can also refer to peanuts and potatoes, but we're not talking about that right now.
We're not, but and what are its origins, though? Do you know that?
No, there are different theories about what the origins of the term are. The origins are not clear. However, by 1911, the Encyclopedia Britannica described the term Redskin when used to refer to Native Americans as a disparaging term. The Encyclopedia Britannica called it a term that was not in good repute. That's how they put it. So it's been a slur for decades and decades and decades since before the team name was assigned.
Well, and is your case that's now pending before the Trademark Trial and Appeal Board, is it going to turn on whether or not there's enough evidence to support the argument that the term is in fact offensive?
The legal standard that the Trademark Trial and Appeal Board set, the test that they set, is whether a substantial composite, that's their term, substantial composite of Native Americans would have viewed the term as disparaging at the time the trademark was registered. In this case, we're challenging 5 trademark registrations, and they were registered between the years 1967 and 1990.
And do you have a substantial portion of Native Americans who say that they find the term offensive?
Yeah, there's all kinds of evidence in our record that that it's viewed as offensive, and it's a disparaging term from testimony of Native American organizations and Native Americans to dictionary definitions, which provide objective evidence of whether the term is disparaging or not.
Well, Jesse, I think we should mention that the team's trademark was canceled back in 1999 by the Patent and Trademark Office, but what actually happened after that cancellation?
Sure. So some other Native Americans had filed a very similar petition in 1992. After 7 years before the Trademark Trial and Appeal Board in 1999, that board directed that the trademarks registrations be canceled. The team then appealed the case to federal court, where it spent another 10 years and took 2 trips to the appellate court. Ultimately, the D.C. Circuit Court of Appeals held that those Native Americans had waited too long after their respective 18th birthdays to bring the petition, and that their petition before the Trademark Trial and Appeal Board was actually untimely and barred by the doctrine of laches. Our clients in this case were young Native Americans, some as young as 18 years old, and we don't think we're going to have any kind of similar problem like laches like the earlier petitioners had. But you're very right to point out, Spencer, that in 1999, hearing the very same case, the Trademark Trial and Appeal Board canceled these trademark registrations.
And as you mentioned, the defense of laches, which actually basically says that the party slept on his or her own rights, you're saying that that's not going to be an issue in the current case?
The team has raised that argument again, but our clients are younger Native Americans. As I said, one of them was only 18 years old, so we're not expecting that to be an issue. So
where are things now in this case? Are you just awaiting a decision from the board?
We're waiting a decision from the Trademark Trial and Appeal Board.
And that could take up to 18 months, is that right?
Well, I don't want to speculate, but we had our oral argument before them earlier this year. I think it was in March, and the case is now under consideration by them.
So you mentioned earlier that if you guys succeed on the merits here, that it will actually cancel the trademark, which isn't going to stop the team from using the name. So what are the effects of the cancellation?
Right. So I want to clarify something. The Trademark Trial and Appeal Board can't cancel a trademark. You get a trademark by just using the mark, but they can cancel the registration. The person who has a trademark can register it with the federal government, and if they do that, they get additional rights in terms of enforcing their trademarks. So their registered trademarks would become unregistered trademarks, somewhat harder to protect and enforce. But this is not a case about censorship or about preventing the use of the term. We certainly hope that people will come to their senses and stop using ethnic slurs for football team names or for any other purpose, but we cannot compel people to do the right thing, but we can take away the federal subsidy in the form of the registration of the trademarks.
And so while you're waiting for the decision from the board, there also seems to be a movement in Congress with them actually trying to cancel registration for the trademark. Can you tell us about the recent House legislation?
Sure. So as I mentioned before, the statute says that a mark that contains matter that may disparage persons cannot be registered. So a bipartisan group of members of the House of Representatives has introduced a bill that would clarify the law and specify specifically that marks that contain the word Redskin in reference to Native Americans shall be deemed disparaging and not subject to registration. And any marks that had that term that were registered, the registrations would be canceled. So in effect, the bill that's before the House of Representatives would accomplish through legislation the same thing that we're trying to get the Trademark Office to do in our petition.
And any sense of when that bill might come up for a vote?
No, it's been referred to a subcommittee
Dan Snyder, who, as I mentioned, owns the team, has said that he will never change the name of the team. So do you think for Dan and also for the NFL that it's about more than just tradition? Is it also about money?
I don't know what motivates them. They have so much money that I don't think it's about money. I'm not sure what it is. It is difficult, I think, for some people to come to the realization that the term really is not appropriate. We've those of us who are sports fans have heard the name ever since we were little kids, and for us, for an adult to step back and reflect and realize that, gee, we were doing something wrong when we were using this team name, it can be a little bit much. But I am really heartened, very heartened, by all the outpouring of support that we've seen from members of the public and from a number of members of the media and sports writers. And I know that time is on our side.
Well, and you say members of the media. I just want to point out that there are some media outlets that have chosen to not use the name when they're referring to the team. Is that what you're talking about? That
is what I'm talking about. And also, there have been a number of outspoken columnists, including in this town in the Washington Post, who have really come out very strongly against the team name.
And just back on the issue of money for just a second, though, according to some estimates, a name change would cost the team more than $20 million, so money might be a little bit of a factor here. But let me ask you this, Jesse, if the public opinion shifts and also pressure begins to mount against the team, could the team, or might it actually change the name on its own accord?
Oh, that's what we're hoping for. I mean, we can't, our petition wouldn't force them to change the team name, and the bill before the Congress wouldn't require them to change the team name. But we're hoping that as society thinks about it some more, and as the NFL and the owners of the team think about it some more, they will recognize that this is a relic from a bygone era, and it's a relic that we don't want to preserve.
Well, we're going to have to stay tuned to see what happens, but times certainly are changing. Thanks so much for joining us today, Jesse, to talk about this issue.
Thank you for having me.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.